ओके सीमा, आपका फेवरेट सब्जेक्ट बताइए।
Ma'am, my favorite subject is Indian Evidence Act. Though I have equally worked hard for each and every subject, but I would say that this is my favorite.
अच्छा।
तो रेस जस्टिस का प्रिंसिपल बताइए।
Basically, the res geste principle has been borrowed from common law, and it is there in Section 6 of the Act, which is to be read with 106 of Indian Evidence Act as well. Res geste is basically, as the name suggests, the things spoken, the things done, basically which are connected with the main transaction, which can happen at the same time or at different times, or which can happen at the same place or a different place.
Okay. So res geste is an exception of hearsay rule, right?
Yes, ma'am.
What is hearsay rule, and can you give us an example?
Yes, ma'am. Hearsay is basically a secondary evidence, which is not expressly a part of Indian Evidence Act, but in the practice of courts, we have accepted hearsay evidence in various parts, in various fields. For example, admission. For example, dying declaration. For example, res geste. So, hearsay linked with res geste. I would like to give an example for the same. For example, an accident took place and some bystanders were there basically witnessing that accident. So basically if that victim says anything about those incidents and one person hears the same and shares the same incident with another person, that is basically hearsay evidence, and which can be admitted because it is linked with the same transaction.
All right. So आपने पलविंदर कौर का केस सुना है?
Yes, ma'am, I have heard it.
So what was the ratio in that case?
Ma'am, basically, I'm not able to recall the exact hearing or the exact judgment, but I think that it deals with dying declaration.
It deals with confessions.
Okay, sorry, ma'am.
ठीक है, शिवानी मैम।
और रिलेवेंसी एंड एडमिसिबिलिटी में क्या डिफरेंस होता है?
Ma'am, basically, the difference between relevancy and admissibility was explained by the Honorable Supreme Court in the landmark judgment of Ram Bihari Yadav versus State of Bihar. The judgment stressed upon the point that relevancy and admissibility are used synonymously, but the legal implications are very much different. Relevancy is basically something which is relevant, which is a part of the record. But admissibility depends upon the judge, that whether a particular piece of evidence is basically going to be the part of the record or not, whether it is going to be admissible or not. So their legal implications are entirely different.
Okay. So tell me that you told us that you are from Punjab.
Yes, ma'am.
If you're selected here,
yes,
and then a vacancy comes up in Punjab, you
yes,
will go, right?
Ma'am, basically, no, ma'am.
Why not?
My point of view on this particular question is that basically I don't want to disturb my seniority. I won't take any chance. Basically, this was my dream, and being this respectable chair, I don't think so that I'll shift to my home state.
Okay. Hi, is this Tanishka? Tanishka, can you join after an hour? Half an hour?
ठीक है। पंजाब के बारे में कुछ बताइए।
Basically, Punjab is a northern state, basically known by the name itself, the collection of the 5 rivers, basically Panj and Ab, that is the formation of the area with the help of 5 rivers. It is a very good state. Recently, there has been many developments going on in Punjab. And also, I have lived at various places in Punjab, like Ludhiana, Hoshiarpur.
So you told us you lived in Chandigarh recently, right? You're living in Chandigarh.
Yes,
so why is Chandigarh capital of 2 states?
Yes, ma'am. Basically, there has been a historical significance behind this particular point, and that relevance is that, like at the time of the partition, basically Punjab was bifurcated into 2 parts: the east Punjab and the West Punjab. East Punjab was retained with us, and whereas West Punjab went with the Pakistan. So at that time, Shimla was basically the capital, summer capital. But as winters proceeded, it was not sustainable for us people to retain this Shimla as our capital for winter times also. So Jawaharlal Nehru suggested that Chandigarh should be formed as the capital of both the states, basically Punjab and Haryana.
Punjab and Haryana were one state when Chandigarh was made the capital.
Yes, ma'am. Yes, ma'am.
Later on, Haryana.
Yes, ma'am. Basically, the bifurcation between Punjab and Haryana is due to the language barriers.
Yeah,
Basically,
language
Punjab
and
has
cultural barriers. Yeah. So
yes, ma'am.
you're telling us that Jawaharlal Nehru made Chandigarh the capital of two states.
Okay,
Chandigarh
ma'am.
was made the capital of one state, that is Punjab, when Punjab
Punjab.
included Haryana. And
Okay,
later
ma'am.
on, what is the how much participation of Punjab government is there in ruling Chandigarh?
Ma'am,
Like what
basically, it has a
percentage?
ratio, I guess there is 70-30 or 60-40, but I'm not sure of this fact.
ठीक है, all right, okay. एक सेकंड होल्ड करते हैं शिवानी मैम, कॉल करके उसको बोल दो कि प्रियंका को कह दीजिए कि कॉल करके उसको बोल दे कि वो थोड़ी देर
मैंने बोल दिया एक्चुअली उसके एंड से कुछ प्रॉब्लम हो रहा है, वो लॉग आउट करने की भी कोशिश कर रही है पर वो बार-बार। ठीक है, मैंने बोल दिया।
कोई बात नहीं, ठीक है।
तो
सीमा आपने
हाँ, पूछो कंटिन्यू करो।
सीमा आपने इंडियन कॉन्ट्रैक्ट एक्ट पढ़ा है?
Yes, ma'am, I have read it.
What are void contracts?
Ma'am, basically, void contracts are those which are not enforceable in the eyes of law.
And what is
The
void
contract
agreement?
void agreement is basically an agreement which has no force in the eyes of law. For example, a minor's agreement is void ab initio.
So you're telling us a void contract is that contract which is not enforceable, and void contract is that contract which is not enforceable, and one has no force of law. Both
Yes,
mean
ma'am.
the same thing. What is the
Ma'am,
difference?
basically, a void agreement is a stage prior to the void contract. Void contract is technically a contract, but due to some inherent lapse or procedural defects, it is not capable of being enforced at law. Whereas void agreement in itself is something void, which is zero. For example, void agreement की अगर मैं example दूं, that is minors agreement is void ab initio. But whereas अगर मैं void contract की example दूं, for example, that contract was valid earlier. But due to some impossibilities, for example, if it is hit by section 56, it turns out to be a void contract.
Unconscionable contract क्या होता है?
Pardon, ma'am, can you repeat it?
Unconscionable contract.
Yes, ma'am. It is basically that contract which no, common person of ordinary prudence would enter it. For example, if a poor and old lady who is suffering from some mental illness gets to sign a contract with another person who is taking his or her advantage, so that will be unconscionable contract.
कहाँ दिया हुआ है ये?
Ma'am, basically it is not expressly mentioned anywhere, but yes, it is a type, and moreover, its reflection can be found in the chapter of undue influence.
Chapter of undue influence. Is there a chapter dedicated to undue influence?
Section, ma'am.
Okay, शिवानी मैम.
सीपीसी पढ़ा है आपने सीमा?
Yes, ma'am.
ठीक है. ट्रांसपोजिशन ऑफ पार्टीज क्या होता है?
Transposition of parties is basically dealt by Order 23, Rule 1A. It deals that, for example, there are two parties, plaintiff 1 and plaintiff 2. And on the other side, there are two defendants, defendant 1 and defendant 2. So now, if a case arises that a defendant wants to leave the suit, he can be transposed as plaintiff if he has some cause of action arising against that one defendant which is left behind.
एग्जाम्पल इसका कहाँ दिया हुआ है, या आप किसी सेक्शन से रिलेट कर सको या ऑर्डर से रिलेट कर सको?
Transposition, ma'am, basically it can also be read with section 21 of Limitation Act.
इसका एग्जाम्पल क्या होगा? मतलब ये कौन से सिचुएशन में बेसिकली किया जाता है, कौन से सूट्स में किया जाता है?
Ma'am, where there is a cause of action which is sustained against the other party. For example, some new facts have arisen due to which the party wants to transpose as plaintiff and not as defendant. For example, a father has filed a case against against his three children. Now, the daughter wants to be transposed as plaintiff because she got to know about the certain facts which came later on. So she can subject to the limitation.
क्या
Is
इंटरप्रेटर
this
सूट
transposition of party या फिर is this um, adding the daughter as plaintiff?
Ma'am, this is transposition of parties.
If you add another plaintiff on record, is this
Ma'am,
trans?
basically, she was a defendant earlier.
Okay,
She got transposed as plaintiff.
all right.
क्या इसका एग्जांपल इंटरप्रेटर सूट हो सकता है?
No, ma'am, I don't think so.
क्यों नहीं हो सकता? Why reason?
Ma'am, basically, interpleader suit stands at a different footing from transposition of parties. Interpleader suits में क्या है? The original claim is between the defendants who are fighting against each other. So basically, to decide that relief plaintiff is filing that suit, here the defendants are not transposed as plaintiffs. Basically, he wants to obtain an indemnity for himself.
Equitable set off क्या होता है?
Ma'am, basically, equitable set off is dealt by Order 20, Rule 11, I guess. And equitable set off is very much different from legal set off. Equitable set off is concerned with the amount which is basically forming a part of the same transaction. Basically, it is a counterclaim only, an independent action in itself.
Demand क्या होता है?
Ma'am, remand is basically sending back the case, which is given in Order 41, Rule 23, 23A. And remand can be on 2 points, basically on a case which is disposed on a preliminary point and a case which is disposed otherwise.
मैं ये
Limitation
बताओ,
expert है? अच्छा, हाँ, ma'am, you continue.
Pardon?
ये
ma'am?
बताइए ये बताइए आपको जज क्यों बनना है? Why do you want to be a judge?
Ma'am, basically there are very reasons, a very large number of reasons that why I want to be a judge. First of all, I would like to disclose that I was 10 years old when I used to visit courts with my mother. Basically, my mother has single-handedly raised me. So this was my dream basically, and this was just another way to pay respect to my mother, who has, despite fighting against all the odds, has raised me single-handedly. So that is why.
Your mother was a civil judge?
No, ma'am. Basically, we were fighting a divorce case with my father. So that is why I used to visit the courts.
So you can pay respect in other ways as well. Like if you become a good person, if you do well wherever you are, you will be ultimately paying respect. Why judiciary?
Ma'am, basically, I was very much fascinated by the courts. And also, after my plus two, when I took admission in 5-year law, I started exploring various career options. So, this was basically something which seems very attractive to me, this respectable job, this respectable chair, and the
But then
aura
there
of a
are
judge.
many other respectable jobs. And advocacy is a
Ma'am,
very respectable job. You are
ma'am,
pursuing PhD, and teaching is a very respectable and noble job.
ma'am, no doubt it is a very respectable job being an advocate, being a teacher. But I feel that I have selected this, and I can say that I have a love for basically the laws, and I have given my time. I have devoted my all the hard work and
While
success.
while advocacy, you will be pursuing law only. So your time in preparing law, in studying law, is not wasted. Similarly, if you teach, you will be teaching law only. Your
Ma'am,
time,
I have not thought of being an advocate or a teacher.
why?
Ma'am, basically, I have interest in being a judge.
Then why did you pursue PhD? Why are you pursuing PhD?
Ma'am, basically, LLM and PhD, I perceive them as my supportive elements. Due to them only, my conceptual clarity has become more and more. I have not pursued them by thinking as an option.
So with this conceptual clarity, don't you think you will be better serving the society as a professor by imparting that knowledge which you have gotten?
Ma'am, no doubt I may be a good teacher, but still I have not thought as an option, and still I have not thought it as a career perspective.
All right. What are your hobbies, Seema?
Ma'am, my hobbies are basically cooking and playing badminton.
बैडमिंटन के कोई प्लेयर्स के नाम बताइए.
Yes, ma'am, Lakshya Sen, who has recently won the Thomas Cup, and also PV Sindhu. She has recently won bronze medal in 2020 Tokyo Olympics.
And the other one was? The other hobby was?
Cooking.
Cooking. What do you like to cook?
Ma'am, I like to bake cakes. I cook according to my
tell
mood.
us a recipe of bread?
Ma'am, yes, I can basically tell. First of all, we have to prepare the flour with maida or whole wheat, and then we have to prepare the yeast.
You can skip this
Okay,
part.
okay, okay, ma'am.
अच्छा सीमा, मुझे ये बताओ, लिमिटेशन एक्ट पढ़ा है आपने?
Yes, ma'am.
सेक्शन 18 क्या बोलता है?
Ma'am, Section 18 of the Limitation Act basically deals with the acknowledgement. It states that if a person makes an acknowledgement before the expiry of the prescribed period, it will extend or it will give a new limitation period. Basically, an acknowledgement is an admission of the existing liability.
इसका कोई एक्सेप्शन है?
मैम, इसका एक्सेप्शन ये हो सकता है कि फॉर एग्जांपल अगर हम यही एक्नॉलेजमेंट आफ्टर द प्रिस्क्राइब्ड पीरियड करते हैं, देन इट इज ऑफ नो यूज.
तो इसका कोई एक्सेप्शन है ही नहीं इस हिसाब से.
मैम, इसका एक एक्सेप्शन तो नहीं हम बोल सकते, बेसिकली यही बोल सकते हैं कि इसके लीगल इम्प्लीकेशंस हैं काफी. जैसे फॉर एग्जांपल इफ वी रिलेट दिस विद सेक्शन 25 क्लॉज 3 ऑफ इंडियन कॉन्ट्रैक्ट एक्ट, देन वी कैन ऑल्सो से दैट कि जब वो टाइम बाद डेट हो जाता है और फिर मतलब हम एक पर्टिकुलर वो साइन कर देते हैं, इन राइटिंग दे देते हैं, देन इट ऑल्सो एक्ट्स एज बेसिकली एन एक्नॉलेजमेंट.
एक्सेप्शन हुआ?
मैम, it all depends upon the ideology, I guess. It is just a miss and match of terminology. So I can say that it is neither an implication nor an exception, but
what is the difference
both.
between implication and exception?
Ma'am, implication is basically the effect. Exception is basically something which is against, which is contrary to the general principle.
So how could they be confused? How could these two words be confused for each other?
मैम, बेसिकली लाइक फॉर एग्जांपल अगर हम देखें कि सेक्शन 18 का इम्प्लीकेशन क्या है, इम्प्लीकेशन तो यही है कि जैसे हम दोबारा वो नहीं कर सकते हैं कि जब एक बार प्रिस्क्राइब पीरियड निकल गया तो उसके बाद अगर हम एक्नॉलेजमेंट करते हैं, इट इज ऑफ नो यूज.
ठीक.
वेलफेयर स्टेट का कॉन्सेप्ट क्या है सीमा?
मैम, वेलफेयर स्टेट का कॉन्सेप्ट इज डेल्ट बाय कॉन्स्टिट्यूशन ऑफ इंडिया, बेसिकली आर्टिकल 39 and various other articles. Welfare state is basically that state under which every wing of the government is focused towards the welfare of the people, basically to remove the economic disparities between the poor and the rich.
गांधीयन प्रिंसिपल्स कहाँ दिए हुए हैं कॉन्स्टिट्यूशन में?
Pardon, ma'am?
गांधीयन प्रिंसिपल्स की बात कहाँ की गई है कॉन्स्टिट्यूशन में?
मैम, बेसिकली आर्टिकल 40 ऑर्गेनाइजेशन ऑफ विलेज पंचायत्स
एंड
खादी एंड विलेज इंडस्ट्रीज
और
यूनिफॉर्म सिविल कोड.
आर्टिकल 311 बताइए.
Article 311 basically deals with the doctrine of pleasure, which states that like the person occupying the union post or the civil post is to be removed at the pleasure of the president or the governor only.
What if अगर इंक्वायरी या डिसिप्लिनरी एक्शन लिया गया है किसी पब्लिक सर्वेंट के अगेंस्ट एंड ड्यू टू द नेशनल इंटरेस्ट या कोई और सोसाइटी के इंटरेस्ट के कारण उसे इंक्वायरी का मौका नहीं दिया गया है, ठीक है, एज गिवन इन आर्टिकल 311, सो क्या वो इसके लिए अपील कर सकता है, और कर सकता है तो कहाँ कर सकता है?
Ma'am, basically, if we talk about the appeal, first
हम्म,
of all, Article 311 Clause 2 carves out three exceptions,
हम्म,
under which one of the exception is that if in national interest or public interest, his right of inquiry is, curtailed, then basically that will not be a problem.
तो
But
क्या
if
इसके
he
लिए कोई
like
अपील ही नहीं है? वो कहीं
मैम
भी नहीं जा
होगी
सकता?
बिल्कुल मैम जा सकता है बिल्कुल ही कैन फाइल एन अपील बिफोर द डिसिप्लिनरी अथॉरिटी ओनली और ही कैन फाइल अ रिट पिटिशन अंडर आर्टिकल 32 और आर्टिकल 226
अपील अपील डिसिप्लिनरी अथॉरिटी के पास ही जाएगी?
डिसिप्लिनरी अथॉरिटी में भी मैम वेरियसली जैसे वो होता है ना कि हायरार्की होती है
हम्म,
तो उस जो सबसे सुपीरियर हायरार्की में वो है उसके पास लाई कर सकती है
डिसिप्लिनरी अथॉरिटी होती क्या है?
डिसिप्लिनरी अथॉरिटी मैम बेसिकली डिपार्टमेंट का ही एक विंग होता है जो
हम्म,
बेसिकली इस इंक्वायरी को डील करता है
हाँ, तो इस विंग के भी ऊपर कोई है?
मैम इस विंग में ही डिफरेंट अगर हायरार्की है तो जो सबसे अपर अथॉरिटी है हम उसके पास एक एप्लीकेशन फाइल कर सकते हैं
एंड दैट विल बी कॉल्ड एन अपील।
यस मैम
अपील कहाँ दिया हुआ है? अपील के प्रोविजंस कहाँ
जनरली
कहाँ दिए हुए हैं? हाँ,
okay ma'am appeal has been dealt by CPC as well as CRPC also
हम्म,
CRPC में बेसिकली जो सेक्शन है वो काफी सारे हैं इसको लेके
हम्म।
372 से लेके 394 तक और CPC में देर आर वेरियस ऑर्डर्स विच आर डीलिंग विद द अपील
डिपार्टमेंटल इंक्वायरीज की अपील डिपार्टमेंटल कमिटी में ही जाएगी, ये प्रोविजन कहाँ है?
मैम आई हैव नॉट रेड सच प्रोविजन
फिर आप कह रहे हो कि डिपार्टमेंटल इंक्वायरी की अपील डिपार्टमेंटल इंक्वायरी में ही जाएगी, कमिटी में ही
मैम
जाएगी?
I'm not, well versed with this provision, but this was just an answer based on my common knowledge of law.
अपील ये बताओ अपील कोर्ट्स के अलावा और बॉडीज में भी जा सकती है, अदर बॉडीज में भी जा सकती है?
Other bodies, as in,
डिपार्टमेंटल कमिटी एज यू सेड।
मैम बेसिकली अगर हम देखें जैसे एडमिनिस्ट्रेटिव ट्राइब्यूनल्स हैं
हाँ,
तो उन्होंने अपने ही एक्ट्स के अंदर मतलब डिफरेंट डिफरेंट एपेलेट अथॉरिटीज बना रखी हैं
हम्म।
तो अगर तो वो अथॉरिटी है तो वहां चली जाएगी अदरवाइज जैसे फॉर एग्जांपल अगर हम दूल्हाबाई
व्हाट
की
इज द
जजमेंट पढ़ें
डिफरेंस बिटवीन एडमिनिस्ट्रेटिव ट्रिब्यूनल, कोर्ट एंड डिपार्टमेंटल कमिटीज?
Okay, ma'am. Basically, the difference between administrative tribunal and court is dealt by the landmark judgment of S.D. Joshi versus High Court of Bombay. Basically, in that particular judgment, they have defined the difference between tribunals and courts. They have highlighted that basically, no doubt, tribunals perform the functions of the court, but yet they cannot be termed as court. Why? Because they are just formed basically for particular purposes whereas courts have a legal air of legal detachment whereas which is very much absent in case of tribunals and concerning with departmental committees they are just basically set up under bylaws of that particular department under which that inquiry is to be held.
ठीक है मैम।
चाइल्ड अब्यूज या हैरेसमेंट को लेकर पहला लॉ कब आया था?
मैम चाइल्ड अब्यूज को लेके सबसे पहले अगर हम देखें बात करें तो सबसे पहले चाइल्ड मैरिज एक्ट की वजह से मतलब हमने जो मैरिज को लेके चाइल्ड मैरिज की जो एज थी सारदा एक्ट के अंदर वो हमने रेस की थी ताकि बेसिकली चाइल्ड मैरिज शुड नॉट बी टेकन एज चाइल्ड अब्यूज फिर उसके बाद हमारे पास काफी सारी कन्वेंशन आई इंडिया रेटिफाइड दोज कन्वेंशन जैसे फॉर एग्जाम्पल कन्वेंशन ऑन द राइट्स ऑफ चाइल्ड फिर उसके बाद पॉक्सो एक्ट ऑल्सो केम
पॉक्सो एक्ट कब आया था?
2012
चाइल्ड का मीनिंग क्या होता है पॉक्सो और जेजा एक्ट में?
According to Section 2D of the POXO Act, a child is basically a person who has not yet attained the age of 18 years. And same goes for JJ Act.
Have you heard
Amenities?
the word young persons?
Young persons.
हाँ,
Yes, ma'am. Basically, its reflection can be found in Section 295 of IPC. And not 295, sorry, ma'am. I cannot recall that section, but there is a section which says that if you distribute obscene objects to young persons who are basically below the age of 20 years, that offense is punishable.
There a separate act for such persons?
Ma'am, I cannot recall any act.
Oh, ma'am.
एमिनिटीज क्या होती है सीमा?
Pardon, ma'am?
एमिनिटीज क्या होती है?
Ma'am, amenities are basically the simple services which are available to a landlord, tenant, which a landlord shall provide to the tenant. Basically, it includes sanitary services, electricity services, tap water services, lavatory services, staircase.
रिवीजन का कॉन्सेप्ट दिया है?
Sorry, ma'am.
रिवीजन का कॉन्सेप्ट दिया है
Rent
किस
control
चीज में?
राजस्थान कंट्रोल एक्ट में?
Yes, ma'am.
अंडर विच सेक्शन?
Ma'am, I cannot recall that section.
ठीक है.